The Fifth Circuit Court of Appeals just dropped an absolute bombshell order that could fundamentally dismantle one of the federal government's most widely used gun control statutes and potentially dozens of other federal laws as well. We just got an official en banc order in the United States versus Squire case, and the Fifth Circuit has officially vacated its prior panel decision to rehear this case en banc. Now, in this case, it's not a Second Amendment Bruin challenge that's really driving this case. Instead, the full Fifth Circuit is taking this case to answer a direct challenge to Congress's authority under the Commerce Clause. Now, the question is, why is the Fifth Circuit suddenly doing this? Well, as Judge Higginson said in his dissent on this order, the Fifth Circuit is directly answering a call that was issued just weeks ago by Justice Clarence Thomas in the case U.S. versus Hamani. Depending on how this case goes, this could be a landmark case that has implications and impacts way beyond just the Second Amendment. And now the court has officially issued an order setting the deadline for the first briefs to be submitted to the en banc panel in this critical challenge. So let's break down what just happened, what Justice Thomas said, and why this case could completely upend federal criminal laws and other laws going forward, because this deals with the Commerce Clause. Now, before we jump into this video, if you like this type of content and you want to ensure that you get it going forward, make sure to subscribe to the channel and also turn on all notifications to never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding upon their benefits to try to give you as much as possible as a member. So if you're interested, if you want to check them out, you can do so using the links down below in the details section, also in the pinned comment. And if you sign up using my code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee. Now, to understand how massive this case is, we have to look at the statute that's really at the center of this case. So that is 18 U.S.C. section 922G1, which is the federal prohibition banning individuals with prior felony convictions from possessing firearms or ammunition. Now, for years, litigants have tried to strike down this federal law, this possession law, using Second Amendment arguments. But in this case, U.S. versus Squire, the defendant challenged his conviction by going after the federal government's power to pass the law in the very first place under the Commerce Clause. Earlier this month, a 3-judge panel ruled against Mr. Squire, and they stuck to precedent that has been issued by the Supreme Court and other courts surrounding the Commerce Clause. But Squire then filed a petition for a rehearing en banc, asking for the entire Fifth Circuit to step in. And then the Fifth Circuit granted the petition, officially vacating that panel opinion. The entire active bench of the Fifth Circuit will now rehear the case and take a hard look at whether mere possession of a firearm, even one that previously crossed state lines, actually falls within Congress's powers to regulate interstate commerce. Now, why did the Fifth Circuit suddenly jump on this issue? As Judge Higginson in the Fifth Circuit in his dissent said on this order, this move directly follows Justice Clarence Thomas and his recent concurrence in U.S. versus Hamani. Now, in Hamani, Justice Thomas, writing alone in a concurrence, explicitly invited lower courts to re-examine the constitutionality of Section 922G under the Commerce Clause. Now, under historical Supreme Court precedent, in cases like U.S. versus Lopez, Congress can regulate 3 categories of commerce. First, the channels of interstate commerce. Second, the instrumentalities, or essentially persons and things in interstate commerce. And finally, third, activities that substantially affect interstate commerce. Now, in Lopez, the Supreme Court struck down the original Gun-Free School Zones Act, Section 922Q, because it had no jurisdictional requirement showing that the gun affected interstate commerce. Now, in response, Congress slapped a jurisdictional hook on Section 922G, meaning as long as a firearm or ammunition ever crossed state lines or is manufactured out of state, the feds claimed authority over that item essentially forever. Now, for 30 years, every federal circuit court accepted this kind of jurisdictional hook that was added into the law. But Justice Thomas questioned recently whether an item simply having crossed a state line at some point in its history gives Congress the power to criminalize local, purely intrastate possession today. The Fifth Circuit, because of this, heard Justice Thomas's call for a review of the Commerce Clause very loud and clear, and now they're stepping in to this very issue. Judge Higginson's dissent from the order granting this case in a rehearing en banc shows how terrified the establishment judiciary really is of this case. He wrote in the dissent that just a few weeks ago, Justice Thomas asked lower courts to re-examine the constitutionality of 18 U.S.C. Section 922G under the Commerce Clause. Already, our court answers the call. We imperil much of the United States Code. Judge Higginson argues that if the Fifth Circuit holds that Section 922G1 lacks a sufficient connection to interstate commerce, it won't just affect gun laws. He points out that this could open the floodgates, calling into question federal statutes and countless other administrative and criminal regulations that rely on the same thin interstate nexus. Now, in his dissent, he kind of raises some what he believes are apocalyptic questions, and he says that this would be terrible. He asks questions like, can felons in other circuits move to Texas, Louisiana, or Mississippi to rearm themselves if the Commerce Clause is struck down in this context? Will thousands of existing 922G convictions in the Fifth Circuit have to be overturned? And these questions all come in because the federal government has built various restrictions and laws kind of on this house of cards, and that house of cards is really built on the Commerce Clause. This judge and others fear that all of that will come falling down with a ruling from the Fifth Circuit against the Commerce Clause and how it's being used in this federal restriction. Now, whether you agree with Judge Higginson's alarmism or the view that this is long overdue and it's a long overdue correction back towards the Constitution's original limits on federal power, one thing is very clear with this case. The Fifth Circuit is preparing to send shockwaves through the federal legal system. Now, the clock is currently ticking and it's running on this historic showdown. Under the court's latest order, the opening en banc briefs are now due and they're set to be submitted on September 3rd. And then the response briefs will be filed, and then oral arguments will probably also be set very soon, maybe even before the end of this year. So if the full Fifth Circuit rules that Section 922G exceeds Congress's Commerce Clause authority, it will create an immediate massive circuit split with every other circuit court in the country, forcing the Supreme Court to likely have to take this case and face Justice Thomas's question head on. So again, this is a critical case. It's not just going to impact the Second Amendment question, but it can create a very critical circuit split on the Commerce Clause itself, and then tee up a very critical re-review by the Supreme Court on this very issue. And again, that has broad-reaching implications because the Commerce Clause is used for a lot of things. So I'm going to be tracking this as it develops, as it moves towards, that September 3rd opening briefs that are going to be filed, and the response briefs, and eventually the oral arguments. I will let you guys know as it develops, but let me know down in the comment section, do you think simple possession of an item manufactured out of state counts as interstate commerce, or has Congress gone way too far with its use of Commerce Clause, using it to put regulations and restrictions on almost everything? Let me know your thoughts down below in the comment section. If you like this type of video and you want to ensure that you get these videos going forward, make sure to like, comment, subscribe, and turn on all notifications. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.